case briefs, and so much more. LSData's got what you're looking for.
In 1987, the New York Supreme Court Appellate Division heard a case involving a man who sustained serious injuries while diving through an inner tube in his friend's 4-foot above-ground pool. The case, Belling v. Haugh's Pools, Limited, centered on whether the pool's manufacturer and retailer could be held responsible for inadequate warnings if it was the proximate cause of the injury. The experienced swimmer sued the manufacturer and retailer, claiming they failed to give adequate warnings of the dangers inherent in diving into a 4-foot pool. However, the defendants argued that the pool was not defectively designed, and the man's own behavior caused the injury. Initially, the court denied the defendants' motion for summary judgment, but it later reversed the decision and granted their motion. The court found that the failure to warn was not a proximate cause of the injury, and no liability exists for failing to warn of obvious dangers that would be appreciated by the user to the same extent that a warning would provide. The court held that the risk of diving in a 4-foot pool was obvious, and the man's behavior caused the injury, not a pool defect. Thus, it determined that the manufacturer and retailer were not responsible for the injury. This case highlighted the idea that while manufacturers can be held responsible for inadequate warnings when they are the proximate cause of an injury, if the user is already aware of the risks, they may not bear any liability.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.